Learned counsel for the applicants submits that the applicant number 1 is the husband who has divorced the opposite party number 2 on 8/11/2015 and also obtained a fatwa from Jama Masjid, Agra on 10/11/2015, whereby the Mufti city Agra has affirmed the talaknama and pronounced that the opposite party number 2 after being divorced has become impure. For the applicant number 1, he submits that after the talak, the applicant number 1 had sent a notice to the opposite party number 2 that in presence of persons oblique officers at Parivar Paramarsh Kendra, Agra, on 8/11/2015, he had divorced her by saying thrice that I divorce you, Sumaila Afghani, and thus made her free to lead her life in the manner she wants. It is also mentioned in the notice that on 10/11/2015 he has obtained a fatwa. He therefore submits that since the applicant number 1 has divorced the opposite party number 2 on 8/11/2015 and as such the application dated 19/11/2015 filed by opposite party number 2 under section 156 under bracket 3 CRPC making certain allegations of malicious and abuse of process of court, and therefore the impugned summoning order dated 28/11/2016 in complaint case number 2393 of 2016 passed by the learned additional chief judicial magistrate court number 10 Agra deserves to be quashed. He further submits that once the applicant number 1 has divorced the opposite party number 2 on 8/11/2015, the question of commission of offence under sections 498A, 323, 504, 506 IPC and section 3/4 Dowry Prohibition Act does not arise at all. In support of his submissions, he referred to the pleadings of paras 5, 12, 13 and 14 of the affidavit accompanying the application, the copy of the intimation of divorce and the copy of the fatwa. He submits that after the aforesaid validly given talak by the applicant number 1 to the opposite party number 2 on 8/11/2015, all her actions including the impugned complaint case proceeding are null and void. Para. Learned counsel for opposite party number 2 submits that in fact the applicants used to beat the opposite party number 2 mercilessly. They were not giving her food to pressurize her parents for dowry. They have forcibly obtained her signature and thumb impression on blank papers. On some papers, they forced and compelled the opposite party number 2 to write and sign as dictated by them. Thereafter, they have ousted the opposite party number 2. He refers to the application of opposite party number 2 dated 19/11/2015 in which the true incidents have been mentioned. He submits that the story of divorce is totally false and in any case it is wholly illegal and unconstitutional, being violative of Articles 14, 15 and 21 of the Constitution of India and thus wholly null and void. He refers the statement of the complaint oblique opposite party number 2 recorded under section 200 CRPC as well as the statement of witnesses under section 202 CRPC. He thus submits that the impugned order does not suffer from any infirmity. Over.